Let's look at the example of invitation to trade. So we have so many examples of invitation to trade here. Actually, we have 6 examples, and we will discuss one by one. Yes, the first is display of goods. Display of goods can be considered also invitation to trade. When normally when you look at the goods displayed in the shop window or maybe in a supermarket, you have to know this just an invitation to the customer to make an offer to buy. And this is illustrated in 2 cases. Now have a look on 2 cases here. We have Fisher versus Bell. What happened in Fisher versus Bell is about a fleet knife which was displayed in a shop window. And what happened, a shopkeeper was charged with offering weapon contrary to the provision of the Restriction of Offensive Weapon Act 1959. So we need to look at whether the display of fleet knife can be considered as invitation to trade or offer. And then the court determined that so it just an invitation to trade, meaning that it was not an offense. Yes, okay, this is the rules, the principles laid down by the court in this case. And then after that, what happened, the legislator, they had amended the law, whereby they say that they said offerings of weapon, so offering may include display of good also. So there are changes of the law after the decision of this case. And next, we move to Pharmaceutical Society of Great Britain versus Boots Chemist Limited. In this case, it's about a pharmacy which displayed a poison and which can be considered as an offense under Pharmacy and Poison Act 1933. Because in this case, what happened, they just put poison on the shelf, but there was no supervision by the pharmacies. But if you can see, in this case, actually the pharmacies was standing at the cashier's desk. So we need to consider whether the display was an invitation to trade or not. So the court found that the payment was to be made at the exit where a cashier was stationed, and at the same time also a pharmacist supervised this transaction, and he would authorize to prevent the sale. So the court said that in this case, so meaning that it is not an offense, and so the display was an invitation to trade, so it is not considered as an offer. So that's in the case of Pharmaceutical Society of Great Britain. Now let's move to advertisement, catalogue and brochures. For advertisement, this type of advertisement, it doesn't involve a reward actually. So we will consider this type of advertisement as invitation to trade. And this also is illustrated in the case of, we have here, we have Petrish versus Crittenden. So it's about the advertisement on Bramble Finch Cock and Hens, 25 cents each. The court held that in this case, the advertisement was just an invitation to trade. Anything happened, so if the buyer did not satisfied with the advertisement, for example, in this case the cock had been sold out, so when the person attended the auction, so it cannot be considered as an acceptance on the part of the plaintiff. So it's just an invitation to trade. So when the plaintiff attended the auction, it's just an offer, and there is no acceptance happen in this case. And then for the next, we have the case of Coelho versus the Public Service Commission. It's similarly applicable in the case of the advertisement relating to job. Yes, okay. So if you look at a job vacancy here, was advertised in the newspaper. Yes, of course, it also can be considered as ITT. And when the person applied for the job, so meaning that he made an offer. In this case, if you look at the facts here, the defendant here, the Public Service Commission, had sent letter of acceptance. So it means there was a contract made between the parties. Okay. However, what happened? Suddenly, the defendant, they terminated the post on the ground that he was on probation, and that's why Coelho, the plaintiff here, he challenged the termination, and the court held that in this case, yes, there was a contract since the company had accepted the proposal, and the defendant, they cannot simply terminate his post, because they need to follow certain procedure in termination. Okay. So the next one, the third, we have auction. You know auction? Yes, of course. So if you look at auction, okay, for normally it will put in the advertisement, and that advertisement, that kind of advertisement also can be considered as ITT. And we have here we have two cases also. We have Pin versus Cave, whereby in this case, okay, actually we need to know the procedure here, the process. When there is an offer, actually, offer, it was made when the person made the highest bid. All right. So when you made a highest bid, it is considered as an offer. But what happened in this case? The person, he withdrew the bid before the fall of hammer. So it means that after the fall of hammer, it could be considered an acceptance, right? And then, but what happened in this case? There was no acceptance since the person revoked it before the fall of hammer. So the court said that there was no contract and the defendant was not bound to purchase the goods. And the next, what we have, the case of Harris versus Nickerson. Yes. If you look at the case of Harris versus Nickerson, it's about the advertisement on auction, and whereby when the person yes he go when he went for the auction sale, he found that there was no office furniture, and he was very frustrated and he sued the defendant for breach of contract. Okay, similarly, the court held that the advertisement was also an ITT, and when the person went to the place for that's mean for a bid, so it means it's just an offer. It's offer here mean when he made the highest bid, so it can be considered as offer, but it was not happen in this case. So the court held that there was no contract. Okay. Next, we look at on tender. Okay, you know tender, of course, it also invitation to trade. Okay, and we have the case here. We have the case actually Spencer versus Harding. In Spencer versus Harding, it's about a letter of tenders for a sale of certain goods, and the court considered in the case letter of tenders was an invitation to trade. Okay, and when the person okay, made an offer, okay, yes, even though the defendant did not accept it, so it doesn't amount to an acceptance. So it means that tender, okay, ISITT, when the person send letter of tender, so it means an offer. So and there is no acceptance since the defendant did not accept it. So the defendant means it means that he has the right to refuse the offer, and the court held that there was no contract. And the next we have company prospectus. Similar, when the company offered the shares to the public, and when the public make an offer to buy the share, it also can be considered as an offer. Okay, and the company, when they offered to the public, it's just an ITT. And then so it's up to company either to accept the offer made by the public or not. And the last one, we have statement of price in negotiation for the sale of land. In the case of land, for example, sometimes maybe one of the parties, they ask about the price for negotiation. And we have the case here, we have Harvey versus Farsi. What happened in Harvey versus Farsi here? We have two parties, of course, whereby Harvey, he sent a telegram to Farsi, and then he asked about the price of bumper hall pen here. Okay, bumper hall pen here refers to the estate. And what happened? Okay, so Harvey, later on he respond. Okay, sorry, at the first instant, Farsi, he gave the price. Okay, he gave the price of bumper hall pen, and then after that, Harvey, he replied that it means that he agreed with the price. And then we need to consider whether there was a contract or not. So the court held that there was no contract. Okay, why? We need to identify why. Because if you look at this one, when Farsi gave the price, it is considered as ITT. And then when Harvey stated that he agreed, it is not an acceptance actually yet. So actually this is just an offer. Okay, so when there is an acceptance, so acceptance, it would happen when the Farsi said I agreed. It's not on the part of Harvey. Okay, so we have finished on example of ITT. Okay, for the next part, we will look at on termination of proposal.